SJC-12545, Commonwealth v. Urban Feliz.
Please. Mr. Rankovic, good morning.
Good morning, Your Honor.
Wait until the clock starts.
Yes, sir.
Now you may proceed.
May it please the court, David Rankovic for Irvin Feliz, who is present in the courtroom. Mr. Feliz is a model of classification. He's a low-risk, non-recidivist, non-contact sex offender. He was on pretrial supervision for 18 months. He never violated. For the last 2.5 years, he's been on probation. He's never violated that either. But every moment of every day for 5 years, he must have a device strapped to his leg that he can never take off. The intrusion is constant, and it's expressive. The ankle monitor sends a message to the world about the deviance and the dangerousness of the person that wears it. But Section 47 requires that that message be sent with no assessment of whether that danger exists on an individual basis. In Corey in 2009, and again in Guzman in 2014, this court said that, quote, the sanction of GPS monitoring appears excessive to the extent that it applies without exception to convicted sex offenders sentenced to a probationary term, regardless of any individualized determination of their dangerousness or risk of reoffense. The evidence offered at the hearing below, the empirical research submitted in the briefing to this court, and the experience of Mr. Feliz all show just how right this court was.
Okay, well, the court is right but if you look at the holding in those two cases, it says there's no due process violation, that the legislature could impose imprisonment as a mandatory minimum, and therefore this is less intrusive. That's the holding in those two cases, right?
Corey's holding is that there's an ex post facto violation, and so it can't be applied. Section 47 can't be applied on an ex post facto basis because it's punitive in effect. Guzman, it doesn't actually use that punitive rationale. Its rationale is purely a rational basis
My
test.
understanding is that we hold in those two cases, tell me if I'm wrong, that the legislature could have imposed imprisonment as a mandatory minimum, at least in the first case, and therefore the intrusion there's not a due process violation, right?
Due respect, no, that's not right. No, the rationale of Guzman, which is the only case that does a due process analysis, Corey, again, does an ex post facto analysis. Guzman's analysis is basically, as it says, it's a rational basis test. And what it says is that there's a rational basis for this statute, but it defers the search and seizure inquiry, the Fourth Amendment, the Article 14.
It defers it, but I don't understand if we conclude that this is an appropriate sentence, imprisonment, the legislature could impose imprisonment here. I'm not saying it's a good idea to do that.
No, I get that.
That this is a less intrusive means. I don't understand why the Fourth Amendment analysis would come to the opposite conclusion of that. It just doesn't make sense to me that if the legislature can impose a much more burdensome, more intrusive, more searching oversight of this person, meaning they're in jail under the lights all the time.
Right.
Why then would we now find that's a Fourth Amendment violation?
Because of the fundamental difference between someone who's incarcerated and someone who's on probation. First of all, that's true in every scenario, every probationary condition. And that logic would just defy LaFrance. I believe it's a woman. Mrs. LaFrance could have been incarcerated, and so therefore it was less intrusive for her to be subject to random searches. And this was actually a subject that was discussed at length during the Guzman argument. And there's no precedential basis for justifying a search or a seizure as punishment. That's just not something this court does. This court's inquiry is under the totality of the circumstances, whether it's reasonable. And LaFrance says that searches of probationers without individualized suspicion and without some sort of front-end judicial scrutiny, in that case reflected in getting a warrant, in this case being reflected in an individualized, what they're calling in North Carolina, Grady hearings. Without that
North Carolina, I didn't hear you.
They're calling them Grady hearings for obviously the Supreme Court case and the post-remand Grady case from the North Carolina Court of Appeals. So Justice Kafker, that's why, because searches and seizures are not justified as punishment. Probation conditions are not justified as punishment. They're justified for the purpose of rehabilitation, for the purpose of deterrence, but they're certainly not justified for punitive purposes. And this court doesn't need to go any further than the LaFrance opinion. LaFrance says Article 14 bars the imposition of suspicionless searches on probationers. And that's exactly what this is. Grady says that attaching a GPS device without consent is a search. That's the United States Supreme Court under the Fourth Amendment, and Article 14 compels the exact same result.
But you're arguing a lot because taking DNA is a search, doing drug testing is a search.
Yes.
We, as a condition of probation or by statute, permit a lot of things which are searches, and our case law, including Eldred most recently, says you can do that under certain circumstances if it's reasonably related to a permissible purpose. So are you saying that any search, that by statute they cannot require any search, or only some types of searches?
Well, if the search fell into the special needs category, and Landry is a good kind of contrary case. That's the case about DNA, taking DNA from people who are convicted. And what that case held was that, first of all, that was a minimal intrusion. Now, if we look at this court's cases, Corey, Goodwin, and the appeals court in Doe v. Parole Board, they all describe the attachment of a GPS device as significantly more onerous and burdensome than the conditions of probation and the requirements of registration. And special needs analysis is just a particularly poor fit for this type of search. Vernonia, a United States Supreme Court case about drug searches of high schoolers playing sports. That case says that for special needs to apply, individualized suspicion has to be, quote, impracticable. And Justice Seifert told us in the previous argument just how high a standard that is. And in this case, it's not only practicable, it's happening. These people are registering. They're subject to a registration obligation that varies based on level 1, 2, 3. So individualized suspicion is not remotely impracticable. And Chandler versus Miller, which is a case out of Georgia about drug testing of people who are candidates for public office, that said that the special needs analysis applies when individualized suspicion would thwart the purpose of the statute. But all the evidence we have at this hearing, all the empirical literature that's been submitted to this court, it all suggests that individualized suspicion will further the purpose of this statute. Because when you apply GPS monitors to people who are low-risk offenders, the study out of Tennessee, the Lowenkamp and Latessa article that's cited in my brief, some of the articles submitted in the Matza-Macdel amicus brief, they all suggest that it can actually increase recidivism because you're disrupting the factors that make that person low risk. And Mr. Feliz is a model of that. He's the lowest risk offender. He's never reoffended. He's had 244 alerts on his GPS device, 4 warrants, but he's never actually violated his probation. If this requirement for individualized suspicion, if this disruption of someone's quality of life applies to anyone, it applies to Mr. Feliz.
Oh, but don't we need to focus? I mean, we have a statute which says the judge must do it. So
Yes.
Don't we need to focus at the time of sentencing as to whether or not it is reasonable in all circumstances for the legislature to do it, as opposed to looking after the fact and seeing how it played out for this individual?
Well, all I can tell you is it's taken 2.5 years for us to get here. So I do think it's instructive to show, kind of to look back and see what's happened. But of course, this would be something that happens at the time of sentencing. And in Mr. Feliz's case, you could actually look at the time of sentencing and see that he was on pretrial supervision for 6 months with a GPS device, and he had 65 alerts during that time. And then he had it taken off in April of 2015, and the whole year passes, and April 22nd, 2016, he pleads guilty. So there actually is kind of some predicate for saying that he doesn't need to be monitored with the GPS in order to not violate the conditions of release or the conditions of what ultimately would be his probation.
Do we need to consider all sex offenses or simply child porn, which is the only sex offense for which he was convicted?
Yeah, yes, Your Honor. I do think there's a cognizable line between the non-contact and contact offenses for 3 reasons.
It's more than non-contact. I mean,
yes,
I mean, lewd and lascivious is
Yes,
non-contact,
right.
But this is
Yes,
beyond that.
Yes, exactly. You could limit it. The only question presented by this case is exactly as Your Honor put it, the narrower category of child pornography offenses. And there's 3 reasons to draw that line. The first is all the evidence and the research submitted at the hearing below does show that online offenders, child pornography offenders, do have a categorically lower risk of recidivism. If you look at page 28 and 29 of the Matza-Macdal amicus brief, it also makes the second point that these are not crimes of geographic proximity. So there's a much less strong deterrent effect to having these people be on GPS monitoring. And the third is that, as the probation brief says at page 30, GPS monitoring without connection to other conditions is not likely to promote either rehabilitation or public safety. That's from the probation department. And this category of offenders are just like Mr. Feliz. He has an exclusion zone, but it's not entered into the ELMO system. He has no curfew. He has no inclusion zone.
These facts you're talking about, do we look at what was presented to the legislature? Because we've got a statute that we have to declare unconstitutional, right?
Right.
Was there an evidentiary presentation to the legislature to support this about reoffenses of sex offenders? And I mean, does that not, any of that matter? I mean, I'm not sure what the record is on this case.
Well, the record in this case is the 3 days of hearings below. The
and
record before the legislature, to be honest with you, I'm not exactly sure.
Well, but is that the relevant, is that relevant?
No, Your Honor, for all the reasons that Your Honor's talked about in the previous case.
Normally, we defer to statutes if there's a rational basis for them. Now, this is more complicated because you're bringing a Fourth Amendment challenge to it, but.
Right,
you know.
and Guzman makes the exact point that I'm making, that the reasonableness inquiry under the Fourth Amendment is fundamentally different than the rational basis inquiry under the Due Process Clause. It's a heavily fact-dependent inquiry.
Yeah, that's a distinction that sounds great. Explain it to me. I don't get how a reasonable basis in one area is different from a rational basis in the other.
It's in the latter portion of my brief, I explain, I think the subheading is a rational search is not necessarily a reasonable one. Because a statute's rational basis, it just needs to be rational. It doesn't need to be true, it doesn't need to be accurate, it doesn't need to actually describe the world that we live in. But if you look at the evidence that's submitted in the briefing to this court, the evidence at the hearing below, there is no evidence that mandatory imposition of GPS monitoring will deter sex offenses or crimes in general. There are studies that show if it's imposed on high-risk offenders, it will deter. But there is absolutely no evidence. The Commonwealth has cited none that show that imposing this on low-risk offenders will actually serve the government's interests. Guzman says this is a highly fact-dependent inquiry. And Your Honor, of course, it is a statute from the legislature, but if you look at footnote 32 in my brief, there are Chandler versus Miller, Payton v. New York, cases where the Supreme Court strikes down state statutes as unreasonable under the Fourth Amendment because as we talked about, I wasn't here, but in the previous case, Your Honor's talked about how statutes can't upend expectations of privacy, and there is nothing more fundamental than this. A warrantless search attaching a device to a person's body for 5 years, that is a search. That upsets reasonable expectations of privacy. That's a physical intrusion to the person. And the fact that it's a statute versus a policy or practice or just a condition imposed in this case can't upend the statutory, can't upend the expectations of privacy. And this is the point that Justice Gorsuch made in his dissent in the Carpenter case. And I urge Your Honors to read that about how statutes can create expectations of privacy, but they cannot extinguish them. And Your Honors, I'll end where I started with Mr. Feliz. I would urge Your Honors to read the letters of support in Mr. Feliz's case, which were submitted.
If I can interrupt for a moment. If you win, the case is remanded to the sentencing judge, and the sentencing judge may determine in his or her discretion whether to impose this condition, correct?
Well, that would be in the alternative. My first request would be to ask Your Honors, and this is derived from all the post-Grady cases in North Carolina, would be to ask Your Honors to vacate the GPS condition because Grady 2 and Griffin I cited in my 16L letter updating this court of some recent authority, they both make the point that the government bears the burden in these hearings. Even though that's a statute too, the government bears the burden in these hearings and they get one bite at the apple. And if they don't satisfy their burden, if they don't meet the test of reasonableness, then what we do, we don't go back and remand and give them another chance.
But they had a statute which said you had no choice but to do it. Why would they have to prove anything?
Well,
I mean, they didn't need to prove, they didn't need to tell the judge that this is a smart thing to do. They said the statute says you must do it.
well, Grady 2 basically says that post Grady 1 North Carolina cases have construed it as requiring an individualized determination in every case.
Okay.
And it puts that burden squarely on the state of North Carolina.
Right,
And
but wouldn't that happen at a new hearing where they would then have to meet that burden?
well, Your Honors, Your Honor, in this case, I think the Commonwealth was certainly on notice of exactly what was happening in this case.
So you're saying that they already had that hearing and that chance?
Yes,
Not that, and you're focusing on your motion, your recent motion, not the sentencing hearing?
yes. They already had that chance. They had that chance.
Did the judge at the sentencing hearing believe he had, or she had discretion not to impose the GPS?
No.
So what was the point of the hearing?
Well, it was the hearing wasn't in front of the sentencing judge. It was in front of Judge Gordon subsequently, and because this was an as-applied challenge to Section 47. So that was the purpose of the hearing, to prove that it was unreasonable to develop the factual record that Your Honor referenced in Guzman as being necessary for an assessment of that issue.
I thought we were talking about at sentencing.
I'm sorry?
I thought we were talking about at sentencing,
Well,
that, as in Grady, as in Grady, North Carolina. You're saying that the Commonwealth would have one shot.
that's right. I'm saying
And you're saying that they've already had their shot.
they've already
I'm
had their
saying
shot.
That was at the sentencing hearing.
And no, I think they had their shot. You could either say at the sentencing hearing, but here there was the post-sentencing 3 days of hearings in front of the motion judge.
And did the motion judge believe he had any discretion?
The motion judge, he rejected the constitutional challenge in the latter 2 to 3 pages of his order. He rejected the constitutional challenge as applied to Mr. Feliz. So he did do that assessment and say that the mandatory statute was still constitutional in his view. But that's wrong for all the reasons I've laid out. So I would urge Your Honors to vacate the GPS order as applied to Mr. Feliz and in the alternative to remand to the sentencing judge for that determination to be made in the first instance.
And just to be clear before you sit down, if you were to lose,
I don't want to think about that, Your Honor.
just bear with me for one brief
Sure.
moment. It happens sometimes. The judge would still have the authority to essentially end the probation early.
That's right. I don't think that's something that the judge should have to choose between, kind of an all or nothing. Either this person's going to be on probation with GPS or they're not. I think our law and the law of probation kind of recognizes the idea of graduated sanctions, giving people encouragement. So I think it would be perfectly appropriate for the judge in the correct case, not in this one, but in the correct case to say GPS is going to be imposed for the first 2 years of probation. If you're perfectly compliant, come back to me, and for the latter 3 years, maybe I'll consider taking it off, because that gives the encouragement to never violate the conditions of probation, to be fully compliant, and giving the judge that discretion. This court's law recognizes in LaPointe, and I think just a month ago in Eldred, that individualized setting of probation conditions is the best way to do this, is the best way to deter and rehabilitate, is to craft conditions that apply to the particular defendant, not just the crime that they committed. And that seems to be suggested also by Grady when it says that we consider the totality of the circumstances. So, as I said, I'd urge Your Honors to vacate the condition or remand in the alternative, and if the court has no further questions, I will rest on my brief.
Thank you.
Thank you.
Ms. Campbell.
Good morning, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. Very simply, General Law, Chapter 265, Section 47 is constitutional, as it does not violate either the Fourth Amendment or Article 14. And before getting to the specifics of the statute, I'd like to highlight 2 key points. The first is that the statute is presumed to be constitutional, and the second, as this court said just 4 years ago in the Cole case, the legislature unquestionably holds power to determine what conduct shall be punishable and to prescribe penalties. This includes, where appropriate, imposing mandatory terms of imprisonment and mandatory enhanced punishment for certain offenses. And that's exactly what Section 47 is. It is tied specifically to the punishment that a defendant should receive and the sentence that he should receive. And a judge when considering the appropriate sentence, can either determine that the defendant is an appropriate candidate for probation or an appropriate candidate for incarceration. And if he is an appropriate candidate for probation, the legislature has prescribed that what should happen because of the offenses that he committed is that he should be subject to GPS monitoring.
What's the limits of that argument? Could the legislature say we are going to pass a statute which says every probationer can be searched without cause?
Your Honor, I think that, no, I think, and it gets to a point that Justice Kafka is making. I think there are due process limitations, and I think there are Eighth Amendment considerations, and typically that's where you see challenges to a sentence. I mean, to any sort of sentence statute that is enacted. As to your specific question as to searches that a legislature could say happen post-conviction, I will say that LaFrance expressly leaves open that question. It says, we express no view on whether the adoption of statutorily authorized regulations governing warrantless searches of probationers and providing for approval of a supervisor would meet the requirements of Article 14 and make a search warrant unnecessary. So it is contemplated that that is something that the legislature could do.
We need to decide that point, sounds like.
Yes, you do. But I'd say that there really, when you're looking at that point, what you have to do is engage in a balancing test.
Well, has Grady decided that point for us?
No, and Grady hasn't decided that point. I'd say because there are very big differences between the statute in North Carolina that's being considered in Grady and in here. I'd say, first of all, Grady just remands it so a determination can be made by the North Carolina courts. But if you look at the statute in Grady, what Grady contemplates is that after certain individuals who have been convicted of offenses have served their term, then they can be subject to GPS monitoring for life. And I'd say that's very different than what the statute here contemplates, which is for a specific probationary period, you will be subject to this monitoring.
Which could be life. There are times in which there are very, very lengthy probationary periods for individuals who are sex offenders.
Correct, that is true, but I would say that there is nothing to stop, like Mr. Feliz has done in this instance, to ask that there be changes to the probationary sentence itself. The judge still maintains discretion to make it shorter. The judge still has discretion to change those sentences based on
No discretion not to impose it.
as to the mandatory GPS monitoring. Correct.
Right.
Does Grady go one step further, though? Does it talk about the need for an individualized inquiry in Grady?
I don't believe it does.
Does it? Okay.
No, I don't
Isn't
believe.
there some discussion of that in there? I may be misremembering, but
I have Grady right here, and
you don't need to reread it here, but I'm
no,
just...
I don't believe that it does. I think it remands it. It says there's a totality of the circumstances test that has to happen. We can't determine on this record whether this is reasonable because we don't have any facts to make that determination.
But isn't that sort of individualized suspicion when you start talking about totality of the circumstances?
I don't believe so because totality of the circumstances in this instance means a weighing of certain factors. It means a weighing of the governmental interest against the weighing of a defendant's privacy interest. The same way, it's hard to look at precedent in this instance because it doesn't neatly fit in. I think the case that provides the best guidance as to how this should be reviewed is Landry. And in Landry, what they do is they do this balancing test. They talk about the governmental need to, obtain DNA and to maintain DNA databases against the privacy interest that an individual has in their DNA.
So, two points that are clear. One is that this is a substantial interest that the government has in monitoring convicted sex offenders, and two, that the convicted sex offender has a lessened expectation of privacy.
Correct.
So take those two and then infuse a gradient to the situation, and the question is, despite those two principles, doesn't totality of circumstances require an individualized determination of how to balance those?
I don't believe so.
Why?
First of all, I don't believe that that's required under the case law, either under the Fourth Amendment or Article 14. So that's the first answer to that. The second is, I believe individualized suspicion itself is not a requirement to make a search reasonable under the Fourth Amendment or Article 14. So this focus on individualized suspicion, I believe, is somewhat of a red herring, because all that really is required is that a search be reasonable. And in the context of a Fourth Amendment challenge to a statute which is presumed to be constitutional, what this court has done, as it did in Landry, is to look at certain factors and engage in a balancing test. And when you engage in those factors, I don't believe, and this is all over the amicus briefs, and it was the focus of the hearing below, which I also didn't understand, but the only governmental interest that the Commonwealth has in this case, and the only purpose for which putting a person on GPS is not just deterrence of future criminal offenses. As this court held in Guzman, the governmental interest in putting someone on probation is deterrence, isolation, incapacitation, retribution, moral reinforcement, and to promote the security and well-being of the general public. And those are factors that you have to infuse in this balancing test that you engage in. I think they're all important and they all should be considered. We shouldn't just focus on one, the deterrent effect, but I disagree with my brother's representations that the Commonwealth did not prove that putting someone on GPS had a deterrent effect. Both experts testified at the hearing, including the defendant's own expert, that putting someone on GPS does have a deterrent effect. And I'd say that, I'm sorry. So to the extent that there's any allegation that the Commonwealth didn't meet the burden that it had to, I would suggest that that's just not borne out by the record at the hearing.
So is it your view that the legislature could require this for all crimes, for all convictions?
No, I think there has to be a rational basis. Again, this goes to due process. I think there has to be...
Deterrence, I mean, would there not be a rational basis for virtually every crime?
There could be.
We are watching you.
Well, the alternative is you go to prison, where we are watching you too. I don't...
No, the alternative can be probation without GPS.
But I think it's important that the legislature, through which it has the power to do, has determined that these specific offenses are ones which would the society, the well-being, especially the protection of children, which is what the act was titled when it was passed, would be furthered through this type of monitoring.
The only issue here, in this case, is whether somebody convicted of solely a child pornography conviction, correct? There was no touching, no approaching of any individual here.
I'm sorry, can you repeat the last?
The defendant here was convicted only of
Child pornography
child
offenses.
pornography.
Correct. However,
The victim in child pornography is the child who is photographed,
correct,
according to law,
correct.
who could be anywhere, whether it be Denmark or anywhere.
Absolutely.
Is it a different analysis when we're dealing with that as opposed to somebody who has actually physically approached a person, whether he or she touches the person or not? Is it a different analysis? Because here it is essentially a virtual crime. Your victim could be anywhere.
I don't believe so, because if you read the testimony of the experts in this case and the case law that has talked about this, when you have child pornography related offenses, there's a re-victimization of the victim every single time that these images are both looked at and distributed throughout.
Right, but that victim is still anywhere, could be in a foreign country.
Sure.
So does it matter that we're not, I mean, this is a different type of crime than other sexual crimes.
It is a different type of crime. I don't think it matters, because just as the person could be in a different country, they could be right here in Massachusetts.
And
So
also, you can identify whether they're in the room where the computer is found, right?
correct.
At the time they're accessing pornography.
Well, it depends on how big the room, it can identify within 30 feet.
Right, whether they're in the house where the pornography was observed.
Correct. But I will say, while it can show that a person is at a certain location, it can't reveal the contents of that location, which I think is a distinguishing factor from a case like La France. But I also say, I also would like to point out that it's not different than the information that a probationer is otherwise required to turn over to probation on a very regular basis, in this instance, every 14 days. They're required to show proof of residency. They're required to report. The case law has recognized that probationers' comings and goings, who they associate with, what they do, who they live with, is highly regulated, and that's okay. So to the extent that that plays into the privacy analysis as well, those are all factors that should be considered and are important.
Can I ask, I have trouble in my own head understanding the difference between this rational basis and reasonable basis. Do you want to address that at all, or?
I do too.
Okay.
To be perfectly honest, I do too. And I think part of the problem is because and this is borne out if you look at the hearing below with the judge below. I had a discourse back and forth about the same exact issue. So I understand your struggle because I also share it. I think the difference is in the test that's employed, but I don't think that the governmental interests that have been found in Guzman go away. I think those are still compelling government interests that have to be weighed. And I agree with Your Honor. I don't understand, and I can't contemplate a situation by which a due process challenge would fail, whereby a Fourth Amendment challenge would be successful.
And the Fourth Amendment standard is, I'm just trying to understand what it's a reason, what is your understanding of the Fourth Amendment standard? I understand the due process challenge. I don't understand the Fourth Amendment challenge is the statute needs to be supported by what?
So there's,
It's not a compelling interest standard or a strict scrutiny standard.
It's not.
But it's not quite a rational basis standard.
it's not quite a rational basis standard. If you look at Landry, what they call it is a balancing test, by which they balance the interests of the government against the privacy interest of the probationer.
But that's a Fourth Amendment standard. Is there going to be a different standard under Article 14, or are we going to, what's the standard under Article 14?
I'm not sure if Landry decided it on I believe it did decide it on Fourth Amendment as opposed to specifically Article 14.
Okay.
The only case which I could find which was specifically an Article 14 challenge was Blood. I think in Blood, they don't provide much context as to how exactly they're applying this Fourth Amendment challenge. They say,
Yeah, I'm just trying to understand whether the chief's distinctions about, or the defendant's distinctions between the different levels of criminality are going to require different factual or legislative fact basis to support. I just don't get that yet.
I don't believe it should, because as I understand my brother's argument, it's either individualized suspicion is needed to conduct this type of search or it's not. And so I don't understand why the type of crime committed would change that analysis.
What if the legislature said, for all person convicted of a property crime, condition of probation is that you permit searches of your person and your home at any time? Because there's a possibility that if you've stolen stuff, it could be in your home.
Yes, and then I think you would look at a person's, even a diminished expectation of privacy, you would look at that expectation of privacy analysis, both in a person's person and in their home, and you would weigh it against the stated governmental
But you may say there's
interest.
a rational basis for it. People often steal things and bring them home,
Correct,
but it may not pass the reasonableness test.
Correct.
So there is a difference.
there is a difference in this instance where you look at the compelling governmental interests and you look at the interests that have been highlighted as appropriate for upholding the statute, at least under a due process claim. I'd say that there is no difference in this situation when you're looking at the reasonableness as compared to those interests and as compared to the defendant's diminished expectation of privacy, especially where the expectation of privacy specifically as to location and specifically as to the location and areas where a defendant could or could not be that's already information that is regularly reported to probation and is not otherwise protected or shielded.
So there's another part of the analysis, I think, that the probationer has in this situation. It's not just the substantial government interest, and there certainly is a substantial government interest in reducing child pornography. Every time it's viewed, you increase demand. And the defendant, probationer, they have a lessened interest. So in that analysis of totality of circumstances, don't we have to also consider how onerous the condition is? And here, it seems that what they're talking about is how onerous the condition is. That's part of the...
That is part of the analysis, and I'd say the judge here, based on the facts that were presented at the evidentiary hearing, found that it was not that onerous. And so those facts, so long as they're supported by evidence, which they were, should be upheld.
Now, were there evidence at the hearing, I'm not saying there is because I haven't read the transcript, but if there were evidence at the hearing that deterrence was not served by the imposition of GPS in these circumstances, what would happen?
I believe it would be one less factor that would be in support of why this was reasonable, but I don't think it necessarily would render the statute unconstitutional because of the other purposes of probation.
Probation, yeah.
I see that my time is up. Unless the court has further questions, I will rest on my brief.
All right, thank you. We'll take our morning break.
All right.